Welcome to Deep Dive.
Great to be here.
Today, we're taking a really close look at something critical for potentially thousands of people living and working here in the U.S.
That's right, employment visas.
Exactly. There's been a pretty significant warning put out recently. It could impact a lot of folks. And, we really want to help you understand what it actually means.
It is a crucial update. It really highlights that the whole landscape for foreign nationals on these visas is, let's say, evolving. There's definitely a renewed focus on strict compliance.
Right.
So our aim today is basically to clarify this new enforcement stance, this tougher stance, and help you make properly informed decisions.
Okay, let's unpack this then. The United States Citizenship and Immigration Services, USCIS, they put out a very direct warning. It wasn't buried in some legal document, right?
Well, not at all.
So what did they actually say? What made it stand out?
Well, what's really fascinating here is just how clear and, frankly, blunt the message was. USCIS put out a public post.
Public? Okay.
Yeah, very public. And it declared, and I'm quoting roughly here, aliens who enter the U.S. on an employment visa but fail to report to their designated employer or leave the job without returning to their home country are in violation of immigration laws and will face legal consequences.
Wow.
Yeah. This isn't just, typical bureaucratic language. It really signals a very clear intention for stricter enforcement. There's not much ambiguity there.
No, definitely not. And those words, legal consequences,
Yeah.
they sound pretty serious. Can you elaborate a bit? What could that actually mean for someone?
Absolutely. And they are serious. If we sort of connect this to the bigger picture, non-compliance, especially failing to show up for the job you were approved for, it can escalate really quickly.
Okay.
We're talking about potential deportation, formal removal proceedings.
Right.
And these things have really long-lasting implications. It affects your ability to stay in the U.S., obviously, but also potentially to ever come back, even just to visit.
So we're talking removal, deportation, not just a fine or something minor.
Precisely. The stakes are very high.
And here's where it gets really interesting, I think, because this wasn't just like a theoretical warning shot.
No.
This alert came after a real-life enforcement action, didn't it? Can you walk us through that specific example? It helps make it concrete.
It does, and it answers that question. How does this actually play out? So, the USCIS warning directly followed a case involving a worker on an H-2A visa.
Okay, H-2A.
Right. This individual didn't report for duty in Florida, where their job was. That was the designated location.
They just didn't show up.
Didn't show up. Later, authorities actually located them way over in Fresno, California.
California. Okay, that's far from Florida.
Very far. And once they were located, they were immediately referred to IC, U.S. Immigration and Customs Enforcement for removal proceedings.
Oh, just like that.
Just like that.
Yeah.
It really underscores how serious the consequences can be and how quickly things can move.
That's a stark example. Now, for folks who might not be familiar, what exactly is an H-2A visa, and why might this case be particularly relevant?
Good question. So the H-2A program, it specifically allows U.S. employers to bring in foreign nationals for temporary agricultural work. Seasonal jobs mainly.
Ah, agricultural work. Okay.
Right. But it's built on very specific conditions. The employer has to prove there's a shortage of suitable U.S. workers available.
Right. They can't just replace local workers.
Exactly. And they have to ensure U.S. workers' wages and conditions aren't negatively affected. Employment is usually granted for up to a year, can be renewed, but there's a maximum stay of 3 years typically.
3 years. Okay.
And after that 3 years, the visa holder has to leave the U.S. for at least 60 days before they can come back on another H-2A.
Got it.
So the key takeaway from this specific case, the Florida-California one, is that simply failing to show up or, abandoning that specific job you were approved for can immediately trigger these severe action. It's not a minor infraction in their eyes.
Okay, so that makes the H-2A situation clear. But what does this mean for someone on, say, an H-1B or an L-1? The visa is more common in tech or corporate roles. Is this warning just for H-2A, or does it apply more broadly?
That is a really crucial point, and the warning from USCIS was explicit about this.
Oh, okay.
It applies to all foreign nationals on employment-based visas, period.
All of them. So H-1B, okay.
H-2A, H-1B, L-1, others. The core message is universal. Your legal status, your right to be in the U.S., it hinges directly on you sticking to the terms of your specific employment.
Okay.
So abandoning that job or just not showing up in the first place, it can put your entire ability to remain in the U.S. at risk. The H-2A case was just the public example they used.
Right, the catalyst maybe?
Exactly. But the principle applies across the board.
That really widens the impact then. It sounds like the responsibility, the burden really lies squarely with the visa holder.
It does.
So given this, tougher stance, what proactive steps can people actually take? What should someone on an employment visa be doing right now to stay compliant and avoid these really significant risks?
Yeah, proactive is the key word. The guidance is pretty clear. Visa holders, and importantly, their dependents too, should take several steps. First, and this is maybe the most important,
Yeah, okay.
consult an immigration attorney before making any changes. Any changes to your job, your location.
Before, not after something happens.
Absolute before. Think of it as prevention. You need to understand the potential immigration consequences of any move before you make it. Things can unravel fast, as we saw.
Right.
Second, make sure you have formal, timely communication, both with your employer and with USCIS if your job ends for whatever reason.
Formal communication, like not just telling your boss.
Exactly. Documented communication. An official resignation letter, keeping records, maybe needing to file specific forms with USCIS, depending on the situation and visa type. Don't just rely on a verbal agreement.
Okay, documentation is key.
Crucial. And finally, the sort of overarching advice is just rigorously comply with all the terms of your visa. Dot the I's, cross the T's. It sounds basic, but it's the best way to mitigate the risk of deportation or, problems down the line with future visas.
Be informed and be compliant.
That's the goal. Informed and meticulously compliant.
This deep dive has really underscored just how vital it is to understand and, more importantly, strictly follow the terms of your employment visa.
Yeah.
It's clearly not just about getting the visa approved, it's about maintaining that status every single day.
Indeed. It really is an ongoing responsibility. The USCIS warning, that H-2A enforcement action, they serve as a pretty powerful reminder that compliance is just paramount. And like we said, proactive legal advice, clear communication, those are really your best defenses against things going wrong.
Okay, so let's just briefly recap the main points for everyone listening.
Good idea.
First, USCIS has definitely tightened its enforcement on employment visas. They've issued a clear public warning.
Right. Stern warning.
And violations, like not reporting to your designated employer or leaving the job improperly, can lead to severe legal consequences. We're talking deportation, removal proceedings.
Yes, the serious end of the spectrum.
And importantly, this warning applies across the board. H-1B, L-1, H-2A, all employment-based visas. It's not specific to one type.
Correct. A universal principle.
So the key advice is for visa holders to be proactive. Consult an immigration attorney before making changes, communicate formally about any job separations, and just meticulously comply with all visa terms.
That sums it up well. Be proactive, communicate clearly, and comply strictly.
Thinking about this intensified focus on individual compliance does make you wonder, how might this shift things in the future? Could it change immigration policies down the road, or maybe even shift more responsibility onto employers?
That's a really interesting thought. It definitely raises questions about the balance of responsibility and how enforcement priorities might shape future policy debates or even employer practices regarding their sponsored workers. It's certainly something to keep a close eye on.
Definitely something to watch.
For sure.
Well, this has been incredibly insightful. Thank you.
My pleasure. Important topic.
All the best to everyone navigating these issues, and we will meet again with another important matter again.